Today, I'm going to go over the three reasons that are very important for you to have your own immigration lawyer if you want to go through the adjustment of status green card process based on an approved EB-23 I-140. And so, a lot of times, people that are in this position getting their green cards, a lot of them are people from India because of the backlogs. They're just numbers of them are piling up, but it's from every country. A lot of times, they rely on their employer's immigration lawyer who's really overworked and has a lot of stuff going on, make it hard for you get the attention that you need. You probably experienced that in your H-1Bs, your Ls. But also, that lawyer in totality is representing the employer and is not always thoughtful of the interest of the adjustment advocate and his family. And these are the top three reasons I want to share with you why you need to have your own independent immigration lawyer when going through the I-485 process, adjustment of status. Even if you're doing consular processing, it is very important to know these and to understand why it's important. First of all, it's for your family, your spouse, and your children. A lot of time, the employer's lawyer don't even keep track of what is going on with the family, and they miss out on things that are very important for them to be able to come to the United States, stay here, and go through the process with you. Or the company just won't pay for it. So you'll be getting a lawyer for them anyways. I had this really nasty scenario where this one woman was able to get an employment-based green card, and she had children overseas. And that time she was on H-1B, but the employer never really got into the children. And by the time they found out their children, it was too late. And they gave the bad advice. And they left the kids outside the country. The mother adjusted status, and the kids had to wait for an IA-24 to get approved to send the case to the embassy for the kids. And by the time that even started, there was a retrogression in the visa bulletin timeline in the blog on the. As you all know, the visa bulletin is a horrible thing that delays the process. And so the kids got stuck outside the United States and are still waiting right now. It's been years for the visa bulletin to come current again for them to come. Had they properly vetted the case and guided them, they would have told the kids to come on their H-4 visas to the United States, apply for adjustment with the mom, and then immediately applied for advanced parole and request an expedite to get that advanced parole approved, then go back home to go to their college and education while their adjustment status case was pending, and would have had their green card years ago. And probably by now, in a year or two, they'll be citizens even. But that didn't happen. Unfortunately, things are still pending and they're stuck. And it's really been a horrible experience for the family because the mother did not have her own independent adjustment of status immigration lawyer handling the case. So this kind of stuff happens a lot. So we've got to be very careful of. Secondly, is to prepare and have a relationship with an attorney, because once you do get the green card, if you're single, you might get married. You want to have advice on how to deal with the marriage green card process. Several years afterwards, you're going to file for naturalization, for citizenship. And if you have a relationship with an attorney that already knows your file, knows your case, knows your history, has your paperwork, and can quickly jump and act and respond to stuff, that's going to send you a lot of time and money than having to hire someone later on. So having that relationship is so important, a long-term relationship with an immigration attorney. Even when you're a citizen, you might turn around and apply for your parents. So this is like a 4, 6, 10-year process of having a long-term relationship. And that's what people, our lawyers at our firm are here for. Again, it's a long-term relationship. And third, and actually the most important, I didn't start with it. I probably should say wait along to the third one to get it. It's regarding portability. So if you are an employee-based case and there's delays in the visa bulletin, there'll be a time, especially in the United States, where you may be able to file for adjustment of status, either based on the date of filing chart. And I'm realizing I'm saying a lot of technical stuff, but I'm assuming you know this because you've been going through this insane process of employment-based immigration. But you might have date of filing, or you may file adjustment of status based on the final action date, but there's so much delays, there's retrogression where nothing is moving forward. Well, if you have a adjustment of status pending for a year, you could use what's called portability. It means change employers. Now, if you don't have your own immigration lawyer, you're not going to know how that works. I mean, you could get one later and ask for them, but what's going to happen is, even if you're able to change your employer, so I-485 spending a year, you want to do portability, a new employer is going to file an I-485J for you to get that in. That new employer needs you to have a work authorization card, EAD, to be able to work for them. So you may have found a new job, but you can't switch, especially if your H-1B or something's not valid anymore, your L-1 or your OPT or whatever it was not valid anymore. That situation causes distress, because then you got to file for a work permit, wait for that to be approved. Could be a month, could be 10 months before you can start the new job. So if you had your own adjustment of status immigration attorney from the very beginning, would say file for adjustment of status, file for advanced parole, trial permission, so that you're not stuck and at a year's mark. You have the flexibility to move jobs, and it just has to be the same or similar jobs. And sometimes you could even be self-employed on that too as well. So it depends on the case. We got to see the facts. But as you see, there's a lot going on in these kind of cases that really is strongly recommended to have your own independent immigration advising you, because the interests and the time and the patience of the other attorneys for the employer may not be on your side. There are a lot of good attorneys I know that do these. One just reality is, when they work for these big companies, especially, they have 1,000 cases. It's hard to keep track of everybody, but we're a boutique firm at our firm that really tracks the individual. It's a long-term relationship, as I said. So we're not trying to do numbers here, trying to spend time with you. And that's what you want to have in your representation. Someone that cares about you, wants to spend time with you and respond to you and plan out things ahead of time, because we know you want to get a green card. You want your family to be there. You want your parents to be there. You want to get citizenship. So it's going to take a long term. And you want someone who's going to be here from you from that beginning to the end and knows what's going on. And that's what we're here for. I'm immigration lawyer John Khosravi. Go to our website to schedule a consultation, jqqlaw.com/contact. That's jqqlaw.com/contact. I wish you the best.